Justice Thurgood Marshall wrote the majority opinion in Barber v. Page 1 year after President Lyndon Johnson appointed him to the nation's highest court. The unanimous decision further illustrates the confrontation right. Barber, which Justice Scalia's Crawford majority cited, illuminates two concepts in Confrontation Clause jurisprudence: what it means to be unavailable and what counts as an opportunity for cross-examination. Justice Marshall's opinion rejected the formalistic approach on which many courts then relied. They reasoned that, if a court could not, as a matter of its own authority, compel a witness to appear because he was in another sovereign's custody, the witness was unavailable as a matter of law. As a matter of fact, however, the federal and state governments had adopted statutes and policies to make prisoners available to prosecutors. Taking a realistic rather than a formalistic approach, Barber held that prosecutors cannot pretend those statutes and policies don't exist to defeat a defendant's right to confront and cross-examine a witness against him. Prosecutors must make a good faith effort, meaning they take the same steps to make a prisoner available for cross-examination as they take when they want to call a prisoner to the stand. Justice Scalia's opinion for the court in Melendez-Diaz v. Massachusetts reaffirmed the prosecutor's duty to bring witnesses to court by rejecting the Commonwealth's argument that admitting a chemical analysis report did not violate the Confrontation Clause because the defendant could have subpoenaed the analyst. The court explained that the Confrontation Clause imposes a burden on prosecutors, not defendants. Having decided that the witness against Barber was not unavailable, the court proceeded to decide whether the preliminary hearing counted as a prior opportunity for cross-examination. The court assumed that Barber's lawyer's decision not to cross-examine the state's witness at that time was a knowing waiver by Barber. It held, however, that the waiver did not extend to the right to cross-examine the witness at trial. Barber had no way to know the witness would be taken from Oklahoma to Texas by federal authorities and not be brought to trial. Again, adopting a realistic rather than a formalistic approach, the court recognized that there is no incentive for a defendant to do a searching cross-examination at a preliminary hearing, in which the judge decides only whether there is grounds to hold the accused for trial. The right to confront witnesses can be abused by contriving to get a witness not to appear to testify. To discourage litigants from rigging trials by causing witnesses to disappear, the common law recognized that the confrontation right can be forfeited. Crawford reaffirmed that the Sixth Amendment right to confrontation includes this limitation, which the court first recognized in the 1879 case Reynolds v. United States. Many years later, the court, in another opinion by Justice Scalia, confirmed that the forfeiture doctrine applies only when the opponent acted with the purpose of preventing the witness from testifying. The accused in Giles v. California was charged with murdering his ex-girlfriend, while he claimed that he shot her in self-defense. The question was whether the prosecution could introduce statements the deceased made to a police officer 3 weeks before the shooting. The state argued that Dwayne Giles forfeited his confrontation right with respect to her statements because he murdered her. The court rejected that argument, holding that a person forfeits his confrontation right only when he purposefully gets a witness not to testify, a rule justified by the need to protect the integrity of trials. The principal concurrence and the dissent both showed particular concern for domestic violence crimes. Unlike the dissenters, Justices Souter and Ginsburg recognized that applying the forfeiture by wrongdoing doctrine when there was no proof that the declarant's absence from trial was purposefully arranged would undermine Crawford. The dissent admitted as much and argued that the Constitution should be flexible to make it easier for states to convict people of crimes. Rule 804 lists hearsay exceptions that can be used only when the declarant is unavailable. Part A of the rule defines unavailability to mean that the declarant is privileged not to testify, refuses to testify on pain of contempt, has no recollection, is sick or dead, or cannot be made to appear under the rationale of Barber v. Page. Rule 804A also includes the statutory forfeiture by wrongdoing provision discussed in Giles. The exceptions in Rule 804B are for former testimony, dying declarations, statements against interest, and statements of personal or family history. In keeping with Barber v. Page, the exception for former testimony requires that the declarant was under oath and also that the opponent had the same motive to develop the testimony through questioning as he would have had the witness testified at trial. The exception for dying declarations applies only in homicide prosecutions and civil cases. The declarant must believe death is imminent, and the statement must be about the cause or circumstances of his death. The rule is justified by necessity and by the fact that such statements are just as reliable as any made under oath. In Shepard v. United States, the court affirmed that the declarant must not merely fear that she is about to die, but must have given up hope that she won't die. Whether that is a declarant's state of mind is determined from the circumstances, with the burden being, as always, on the proponent of the statement. Shepard also held that the declarant's statement could not be admitted as evidence that her state of mind was inconsistent with suicidal intentions because it was offered to prove her memory that her husband had poisoned her. The court reaffirmed Hillman, but also held that it marked the outer boundary of the state of mind exception. The exception for statements against interest originally applied only to statements that exposed one to civil liability or extinguished a claim, statements that could cost the defendant to lose a civil case. It ultimately came to also embrace statements exposing the declarant to criminal liability as well, as Justice Holmes argued it should in a dissent. In Donnelly v. United States, the accused was convicted of a murder on Indian land, even though another man admitted to having committed the crime. The confession was excluded on hearsay grounds. Holmes's requirement that such statements be admissible only when corroborated by the surrounding circumstances, such as the declarant did not know Donnelly and thus had no reason to lie for him, remains part of the rule today. There is one last hearsay exception in addition to those found in Rules 803 and 804, and that is Rule 807's residual exception. The Advisory Committee originally drafted the lists in Rules 803 and 804 as mere examples of reliable hearsay. That approach was rejected, and instead, each rule was cast as an exhaustive list of exceptions with a catch-all residual provision at the end. Those provisions were later recodified as Rule 807, which was recently simplified. The current version requires that the hearsay be reliable and more probative than any other available evidence. Ninth Circuit Judge Alex Kozinski famously applied the rule in his dissent in United States v. Ramirez-Lopez. Judge Kozinski's opinion was so scathing that even though the Department of Justice won the appeal, it moved to vacate the conviction on remand and dismiss the case. The opinion echoes Barber v. Page in emphasizing the prosecutor's duty to afford the defendant a fair trial by ensuring that all known potential witnesses are made available to the defense through measures equal to those the prosecution takes when it wants a witness for its case. Judge Kozinski rejected the majority's assertion that the agent's interview notes of the witnesses deported to Mexico were merely cumulative and thus excludable under Rule 403. Cumulative evidence is superfluous or redundant. The fact that all the witnesses in this case said that Juan Ramirez-Lopez was not the guide who brought them into the United States was corroborative, not cumulative, because each witness's testimony verified every other's, casting very serious doubt on the government's case. As Judge Posner said in United States v. Boyce, evidence is admissible under Rule 807 when it is reliable, intelligible, and should in fairness be considered. That approach is essentially the one Judge Kaczynski applied in Ramirez-Lopez. Comparing the agent's witness interview notes to a recorded recollection, he reasoned that the witnesses had no reason to lie and would understand that lying to police is a grave matter. This is the same rationale given by the Davis majority for why statements to police are testimonial. Lying to police has consequences similar to those for lying under oath. Additionally, the agents had no reason to make exculpatory notes other than to be accurate.